All right, we're live.
All right, everyone, thank you for your patience on that longer than expected break. Let's see, we are back at work on H 588, which is our office of professional regulation. Bill, and first I want to ask Michael Warren, the Chief Inspector, the Office of Professional Regulation, the Secretary of State's office, to come up. And he is going to speak to us about the components relevant to his work in the bill. Section we've been taking a lot of testimony and conversation on, so really appreciate your time and your perspective. How you doing today, sir?
I'm good. For the record, my name is Michael Warren. I'm actually the Chief Investigator at the Office of Professional Regulation. And everybody's all set. I'll go ahead.
Yeah, the table is yours, sir.
Yeah, I'm mostly going to read from my testimony just as I think that'll be the most accurate, but feel free to stop me at any time if you have questions, and I'm happy to elaborate. For background, I'm currently the Chief Investigator at the Office of Professional Regulation. I've been employed by OPR since January of 2019, so just over 7 years now. Prior to my time at OPR, I was employed by the Burlington Police Department for just shy of 21 years. During that time, I served as a patrol officer, a patrol supervisor, as the rank of sergeant. I was a detective, investigated major crimes. I also investigated internet crimes against children cases. I worked on the DEA Drug Task Force for 4 years and eventually became a lieutenant at the Burlington Police Department, overseeing the Detective Bureau, in which all major crimes were investigated for the city of Burlington. I also oversaw the drug unit at that time. During my time at Burlington Police, I served as the director for the Chittenden Unit for Special Investigations, also known as CUSI. It's a countywide sex crimes unit that's supervised by the Burlington Police Department. In that role, I was a member of the Vermont Human Trafficking Task Force that was organized and ran by the U.S. Attorney's Office in Burlington. I received related human and sex trafficking training. I conducted and supervised investigations of human and sex trafficking, and I also assisted other state agencies with those investigations. I'm here to talk today about massage establishment registrations. And I want to talk a little bit about the difference between the types of credentials that we have in our office. We often refer to the credentials as licenses, but they're actually, there are three different types of credentials. There's registration, there's certification, and licensure itself. So I'm going to break these down and talk just a little bit to make sure that everybody understands the difference. Registration is when folks practicing a profession are required to register with OPR. As part of the registration, consumers can search our website to verify if someone is properly registered. They can see if there's any discipline against that registrant, and they can review the rules and regulations of the profession to verify if they're following the rules. Registration allows OPR to prosecute registered professionals for misconduct and, if necessary, remove them from the marketplace by revoking their registration. There are no qualification-based requirements for registration for folks that are required to register. Certification is a voluntary credential that OPR has, and that is when individuals can receive the certification. It's generally based on meeting certain training or educational requirements to call yourself certified. Currently, we have certified dietitians as an example of a profession where some folks can become certified, but it's not a requirement. It's a requirement to use the term certification. So if somebody says I'm a certified dietitian, they must actually have that credential. But as long as they're not using the term certification, there are some professions that you don't actually need to be certified by OPR. And the most strict form of a credential that we have is licensure. It's the highest level at OPR and it's qualification based. So there are usually educational requirements as well as continuing education each licensing cycle. There are sometimes minimum practice hour requirements. There's exams, there's supervised practice and other requirements as part of licensure. So those are really the three types of credentials that OPR has. To recap some of our earlier testimony regarding OPR's current recommendations, Vermont regulates individual massage therapists, body workers, and touch professionals through registration. This means that everyone practicing the profession must register with the state, but no qualifications are required. This allows OPR to remove bad actors from the marketplace while leaving others free to work. We explained in the 2021 and 2024 reports that we issued that registration rather than qualifications-based licensure is the right size approach to regulate this profession in accordance with our public protection mandates under Title 26, Chapter 57. And I believe based on my knowledge and experience, I believe that registration continues to be the correct form of regulation for these professionals. H 588, the OPR bill would not change the regulation of individual practitioners. Instead, it would give OPR regulatory power over locations where massage is practiced through a system of registration. The purpose of registration is to strengthen public protection in the fight against human trafficking. You previously heard testimony of Deputy Chief Chris Bowdish in our office, who provided statistics related to the complaints and discipline that have occurred in these professions since we began regulating them April 1st of 2021. More recently, this committee heard testimony from Lieutenant Michael Student from the Vermont State Police, as well as Windham County State's Attorney Steve Brown regarding their concerns around human and sex trafficking within illicit massage businesses. OPR investigators, including myself, have partnered with both of these professionals on human and sex trafficking cases. I appreciate the experience and dedication that they apply towards helping victims of these cases in Vermont. The purpose of my testimony today is to validate the concerns that were brought to you by Lieutenant Student and Attorney Brown, but also to clarify some confusion around the current law and also reiterate OPR's recommendation for registration, not licensure, of massage establishments. You previously heard Lieutenant Student state that human sex trafficking investigations are extremely difficult to conduct, they're time-consuming, they're challenging with the cultural and language barriers that exist. They require significant resources, and in most cases, the folks providing the massage are the victims of sex trafficking and not someone that we want to charge criminally with prostitution or any other related crimes. Lieutenant Student stated that there needs to be oversight of the businesses so we can stop them from exploiting the women who are being trafficked. And he testified that there needs to be business licensure to achieve this oversight. You also previously heard testimony of Attorney Brown, who stated the committee should consider establishing licensure because establishment registration is not working. However, currently there is no system of massage establishment registration in place. There's a business registration through the Secretary of State's office as a business entity, but there is no current registration for massage establishments through OPR. H 588 would create that system. It would give OPR exactly the tools that Lieutenant Stubin and Attorney Brown said are needed for regulating massage businesses. Currently, the only folks we can prosecute connected to illicit massage businesses are the practitioners themselves, but we're not interested in charging these folks as they're they're victims of human and sex trafficking. If establishment registration were in place, the businesses themselves could be prosecuted and ultimately closed for engaging in unprofessional conduct. We could also prosecute unregistered massage businesses for unauthorized practice. This is often much simpler to prove than human or sex trafficking, even when that is the underlying concern. Establishment registration would be just as effective as licensure in protecting victims of human and sex trafficking. Unlike registration, licensure would unfairly put costly and difficult to attain regulations on those that are and have been practicing professionally and competently for many years. It could inadvertently push some legitimate businesses and practitioners out of the marketplace. In contrast, establishment registration would empower OPR to prosecute massage establishments operated by human and sex traffickers without harming legitimate small business owners. In closing, I don't want to overstate the power of any form of professional regulation in this area. In my experience as a Vermont law enforcement officer, having investigated sex crimes for many years, Solving the issue of human and sex trafficking is not a task that OPR can do alone. If Vermont wants to get serious about human and sex trafficking, we need a coordinated approach that involves agencies like the Attorney General's office, each individual state's attorney's office, the U.S. Attorney's office, and other federal partners, local and state law enforcement leaders. Massage establishment regulation is one small but important piece of this puzzle. OPR is recommending that registration of massage establishments is the proper form of regulation at this time. And I want to thank everybody on this committee for hearing about this important testimony.
Could you explain, please, the difference between registering as a business with the Secretary of State's office and registering as an establishment with the Office of Professional Regulation, just so we're clear on the difference between
Sure.
criteria for those two things?
Yeah. Sure. The Secretary of State's office has different divisions. They have the Corporation Business Division, they have the Office of Professional Regulation, they have the Elections Division. All businesses in Vermont, whether it's an LLC or a corporation, sole proprietorship, they all have to register as a business with the Secretary of State's Business Division. That's independent of any license or registration that would occur through OPR. So businesses that are not regulated by OPR, there's so many that are regulated by OPR, but if you own a business that you are not required to be registered through OPR, you still have to register your business with the state of Vermont. That's done through the business division within the Secretary of State's office. That is a completely separate business registration than what we would be requiring from a professional regulation standpoint. So home contractors currently are required to be registered with OPR. But if they own, if I'm a home contractor and I have Mike's remodeling, I have to register my LLC with the Secretary of State Business Division, and I also have to be registered with OPR as a contractor if I meet the criteria for that. So I would have to have two registrations. They offer two different types of protections to the public. So in this case, massage establishments, while they may have a business registration, there is not oversight by the Office of Professional Regulation to be able to remove that registration or the ability for them to continue to practice. And that's what the registration that we are recommending would be in place to do.
Thank you.
I was wondering if you could talk about if there's anything at the local level that would make it easier for OPR to work with local law enforcement. I think there might be sometimes it sounds like from the other testimony, some hesitancy around what the authority is and who has it, whether it's, health officer or zoning or the police departments, or if there's anything else that we could do, maybe not now, but in the future to help that coordination happen better.
Yeah, it's a hard question to answer because there's so many entities that touch the world in which this human and sex trafficking occurs. And so there is local zoning regulations, there are health regulations, there are local police departments. It's because of the challenges culturally, both just in communicating with people and understanding the way that victims of human sex trafficking are navigating through the world. It's often very challenging it's very challenging for one entity to be able to interact and have an impact as the zoning person, because they have very specific things that they're regulating, whether it's sleeping in the establishment. A lot of these businesses, they have the bed set up and people are sleeping there around the clock. But the zoning folks don't really have enforcement or the ability to be out there at 11 o'clock at night to be able to see, what's happening. And you may have to have law enforcement that is looking at that stuff and reporting it to the local zoning, but it's challenging because these businesses fly under the radar. They, for the most part, try not to create any problems. They operate very quietly. And when you try to communicate with them, it's very difficult just language wise to communicate, whether or not they legitimately speak English or not. It becomes a challenge. And honestly, in my experience, what I've seen is most of the different groups of people that would have the ability to have an interaction don't have the time or the ability to be able to deal with it, and they don't, because it's very challenging. So that's, in here, I said that there really needs to be a coordinated approach. When I was on the human trafficking task force run by the U.S. Attorney's Office, it seemed like there were, it's such a complex issue. And the victims rarely ever testify in cases. They rarely ever even stick around in cases. And so it's just extremely difficult to prosecute cases involving human or sex trafficking. Every system is so overworked that it's easy to focus on the things that are much easier to deal with. I'm not sure that I have a real easy answer on the best way to try to help all these different entities come together. I'm not sure I have an answer, which is why it is such a problem and why it does exist. Certainly.
Any other questions for Mr. Warren? So your position is at the current structure in the bill with the registration.
Yeah, I think Attorney Brown and Lieutenant Student, I actually talked with Lieutenant Student after watching their testimony and explained that I was going to be coming back in and that it was OPR's position that we would be recommending registration, not licensure. I've worked with both of them in the past, and I certainly don't want them to think that we're trying to work against them, because this is extremely important work. I've done it for the last 10 to 15 years myself. I have done the investigations. I see the impact it has on the women that are working in these establishments that are providing sex services all day, every day of the week. And so I wanted to make sure that they understood that we want the same things that they want, and that we felt that registration was the correct thing. Lieutenant Student said to me, he doesn't care whether it's registration or licensure. He wants businesses to be able to be held accountable. And I think just like in our office, we use the term licensure a lot because it's how we refer to it. It's really a credential, and the credentials are registration, certification, or licensure. And I think that, I can't speak for Attorney Brown because I wasn't able to connect with him. But I know Lieutenant Student said it doesn't matter whether it's registration or licensure. There just needs to be some oversight of the businesses. And that really is what OPR is trying to do. There was a case in Brattleboro that we worked on very, very closely with them. And it's frustrating and challenging from OPR's perspective to go in and not have the ability to shut down that business. And we don't want to go after the individual people that are working there. And as soon as law enforcement gets involved, those individual people leave and a new group of individual people come in, but there's always still a single business entity. And that's really what we're looking to try to have the ability to impact that business. And I think registration is a good first step for that. Whether it's registration or licensure, we still have the ability to prosecute them, to remove their registration. It's just whether or not there are qualifications based, things for them to get there. And whether there are qualifications or not, we still have the ability to remove them. And we think that that's what's appropriate at this time.
So if it were registration, but for the business rather than licensure for the people working there, the OPR would still have the ability to investigate, to inspect without warning, to do all of those things that they need to do, right?
For registration of the business, I don't have the exact how we wrote it into the current bill. You mentioned inspections. I know there's some conditions of inspection, but yeah, if it's a registration or a licensure, we would still have the ability to go and do the investigation. And if we identify that there is unprofessional conduct occurring, which human or sex trafficking would be an element of that, then we could prosecute them for unprofessional conduct, and ultimately, it's, obviously up to an administrative law officer through our regulatory process. But if there was sufficient evidence, the ALO could remove their registration, which would allow them to no longer practice as a business. Without the business registration, if they continue to practice, then it would be a criminal charge of unauthorized practice for the person who is running and managing the business. So it would allow the regulatory oversight. If they don't comply, then there is a criminal component that would allow us to then, hold that business owner liable.
Thank you.
Any other hands? Yeah, thank you very much for the time and for the testimony, both on written and off script. So it's greatly appreciated.
Yeah, no problem.
And we're gonna move over to Mr. Devlin now.
Thank you, guys.
Thank you. There's a updated draft that's posted on the website we sent out to the committee earlier today. With some updated language, mostly around the speech pathologists, but I wanted to give Mr. Devlin an opportunity to review that with this ever-evolving document. How you doing, council?
Doing well. Thank you very much for having me, committee members. For the record, my name is Tim Devlin, Legislative Counsel. And before you, you have, draft 4.1 of the committee's amendment, strike all amendment to H588, the miscellaneous OPR bill. It's the shorthand of this. Two main changes in this bill. One is adjusting the speech language pathologist chapter under Title 26 to include as the chapter that requires licensure for speech language pathologists, and to expand that to also include licensure for speech language pathologist assistants. And it really just kind of adjusts existing language to insert the additional licensure requirement. The other thing it does too is it rearranges the sections in the bill so that they follow the same order in which they appear in Title 26. And I plan on updating that overview that the committee has been referencing to date so that everything will align for next time. But right now, I would direct your attention to page 21. And the highlighted language is what has been added here. And really the only other highlights we have are the effective dates, which again were changed because I rearranged the sections in the bill. So the first thing we change is the title of Chapter 87. Now reads speech language pathologists and speech language pathologist assistants. And we change one definition. And I left in here for the committees as a reference the definition of what the practice of speech language pathology includes, in case you're curious. But we have, at the top of page 23, the additional definition of what it means to be a speech language pathologist assistant, which means a person licensed to practice speech language pathology under this chapter in a limited capacity as determined by rule. So first right there basically means the exact same thing as a speech language pathology, only introduces the term limited capacity. And what is that limited capacity is to be determined by rule by OPR. So if the committee wants to change that language, just let me know. Happy to do that. Or that mechanism for how that limited capacity is determined. Next, we move on to section 4452, also on 23, which will amend prohibitions and penalties. And here we have description of what a person shall not do. And we add speech language pathologist assistants after pathologists. when it comes to how the individual may display insignias or letters indicating that they're qualified or credentialed. Next, we move on to page 24, and we have the directors of duties under section 4456. And first thing we do is just kind of clean up a typo. There was no subsection B, and so there really doesn't need to be a reference to subsection A. And then again, where it appears that we have, let's see, under the directors, a duty to prepare and maintain a registry of licensed pathologists. We also add assistants there, page 25 under subdivision 7. And then we go down to the more substantive change we have here that I think the committee needs to concentrate on, and that's again on page 25, section 4457, licensure, applications, and eligibility. And these are the provisions having to do with the prerequisites for applicants and what they need education and experience to qualify for this license. And first thing we do is break it out into what the requirements are for pathologists under 1. And then flipping across the page to page 26, we have 2 requirements for speech language pathologist assistants. And I just want to note off the bat that these requirements for the assistants are just placeholders. So I would recommend the committee take testimony to determine how appropriate these are. They, in some sense, mimic what we have for pathologists with a lesser educational requirement. That's just a starting place. I'm not grounding that in anything particular. Just educated filler is what I'd call it. So I suggest the committee think on that. And that's really it at this point. Would the committee like me to go into any other detail about changes in this draft?
Yeah, no, I mean, definitely we need to evaluate the language that's proposed here and bring in testimony for sure. So just for recollection, this is based off of testimony from the speech pathologists last week. And it's has been, to my recollection, an ongoing conversation for a while. So any questions about the words on the page for council right now? So I just want to go back to an email that went out to committee earlier. Do you have anything else to add there, Mr. Delon?
Nothing for me.
Let's see. There was a conversation around nursing language also. That went out in the email this morning. And did the committee members have a chance to take a look at that?
It was at 9:02 this morning
Yeah.
from Nick to the whole committee. Revision regarding APRN renewal.
And we have a little bit of time here, so I wanted to touch on that just for like a little like background and context. And the origin of that was to the registered nurses, and it seems to be. Do you have a share screen capacity?
I don't, I'd have to log into the Zoom. first.
Okay. So, Nick, could you post that? Oh, it is on our page? Okay. So looking at that, I guess you wouldn't mind, Tim, just like speak to it. It seems pretty.
Sure. So, Title 26, Chapter 28 has to do with nursing. Subchapter 2 has to do with advanced practice registered nurses. There is a renewal, and APRN is advanced practice registered nurses for reference. OPRs provide a suggested amendment to 26-16-14 having to do with APRN renewal. Right now, the current statute is just 3 subdivisions that reads an APRN license renewal application shall include 1, documentation of completion of the APRN practice requirement, 2, possession of a current certification by the National APRN Specialty Certifying Organization, and 3, a current collaborative provider agreement if required for transition to practice. And OPR is suggesting striking 1, that is documentation of completion of the APR and practice requirement. And as far as drafting is concerned, very simple. It would just be trying that. It is a matter of policy discretion. So for any reason why I would, as to justifying it or policy objectives trying to be met here, I would defer to OPR.
Okay. Perhaps some, yeah, I mean,
That
you,
seems-
you live in and around this world, yeah.
Yeah. Yeah, it seems very similar to the language around my profession for occupational therapy. Because we have to get, I just certified through NBCOT, which is my national, like the national ARPN, I just national board certification OT. And those practice hours, like it does take that. I don't have to submit twice, if that makes sense. It's like NBCOT approved me. I don't have to prove it twice for the state of Vermont. They just do the same.
Representative Engel?
And my understanding is that physician assistants who are similar in practice to nurse practitioners are under the same guidelines.
So is the committee comfortable with this including
Yeah.
in the bill? Thank you, Tim. Okay, so there's a couple of updates there, but we're really seem like we're like getting close to having this OPR bill in a place where we can do a final discussion. My hope is to be able to do that like middle-ish of next week. That's the desired like a Wednesday-ish. Wrap this up at least for this stop to get it out the door and moving. So does that sound like a reasonable timeline to everyone? All right. Up next, we got a couple of minutes till bill introduction, so we're gonna hold on that timeline. So Nick, take us off before we come back for an introduction, a walkthrough on something Rep. Coffin put in H 831, which is an act relating to requiring the Secretary of State to include the year of passage in the number assigned to acts of the General Assembly. So